Okay, let's unpack this. Imagine you're trying to figure out how someone's property will be transferred maybe, to a family member, a friend, or as part of an estate plan. It can get really complicated with terms like gift deed, settlement deed, and will all flying around.
Yeah.
But the Supreme Court recently brought some much-needed clarity, which is great.
Yeah, absolutely. And what's fascinating here is how the court meticulously laid out the distinctions, really cutting through the legal jargon to provide a clear framework. This deep dive, hopefully, will offer you a shortcut to understanding these crucial differences straight from the highest court. Our mission is really to clarify when property rights actually transfer, that timing. That's the key to all of this.
So what does this all mean for us then? Let's start with the definitions the court actually provided. How do they break down these terms?
Right. So the court explained that a gift is basically a voluntary transfer. It's made without any consideration, so no payment or exchange involved. And crucially, it requires acceptance during the donor's lifetime. For immovable property, like a house or land, registration is mandatory.
Okay, registration's a must for property.
Yes. And here's where it gets really interesting. The court clarified that physical possession of the property is not mandatory for a gift to be valid. As long as the recipient accepts it, that acceptance is the key part.
Ah, that is a key detail. Acceptance, not necessarily having the keys in hand right away. Okay, what about a settlement then? How does that fit in?
Good question. A settlement is also a voluntary transfer. Often it's made out of, love, care, and affection. Think within a family context, usually. The critical part is that it immediately creates rights in the property for the recipient. This happens even if the transfer reserves a life interest for themselves, meaning they can still use the property while they're alive.
So the rights transfer instantly, even if they don't move in yet.
Exactly. If we connect this to the bigger picture, the consideration for a settlement is often that mutual love and affection leading to, immediate satisfaction and the vesting of those rights.
Okay, that makes sense. And the third one, a will. That seems different again.
A will is distinct, yes. The court emphasized that a will really only takes effect after the testator's death, the person who made the will. It's essentially, as the court put it, a declaration of the intention of the testator in disposition of his property in a particular manner. And because it only kicks in after death, that's why a will is inherently revocable during the testator's lifetime. You can change it.
Right, you can change your mind. So with these differences, especially around timing, what's the ultimate test the court gave us to tell them apart? If you're looking at a document, how do you know?
The court stated it very clearly. The legal effect depends entirely on whether the transfer is immediate or post-death. That's the core question. For a gift or a settlement, the transfer of interest happens immediately during the maker's lifetime. But for a will, the transfer happens only after the maker's death.
Okay.
And this raises an important point. If property rights are vested immediately legally transferred right then and there, even if the actual delivery of possession comes later, it cannot be a will. The immediacy rules it out.
That's a crucial aha moment, isn't it? So forget what the document is called. If the rights transfer now, it's not a will, period.
Precisely. The court made it very clear. The nomenclature, the title of the instrument, is immaterial. Doesn't matter what it's called. The true nature of the document is derived from its contents, from what it actually does with the property rights.
So read the fine print, basically.
Essentially, yes. The court even acknowledged that a document transferring interest both in presente immediately and in future can exist. They called it a composite document. It could act as both a settlement for some aspects and a will for others. Such a document would need registration, and the respective rights would flow from it at different times. And just to be clear, the fact that a document is registered also doesn't automatically mean it's not a will, because wills don't always need registration.
Wow. Okay, so it can get complex with those composite ones. Could you give us an example from the specific case the court looked at? How did this play out in practice?
Certainly. In the case before them, a woman transferred property to her daughter. It was clearly stated as being out of love and affection. She retained a life interest for herself, meaning she could continue living there. Now, the daughter didn't get immediate physical possession, but she accepted the property papers, and crucially, they registered the deed.
Okay. So what did the court decide that was?
The court held this was a settlement deed. It fulfilled the requirements of both a gift, voluntary transfer accepted, and a settlement, immediate vesting of rights, even with a life interest.
Even though possession wasn't immediate, that's the part people might stumble on.
Exactly. And the court specifically clarified this. Delivery of physical possession is not a requirement for validating a gift or a settlement. What mattered was the daughter's acceptance, shown by her taking the property documents and the fact the document was acted upon registered during the executant's lifetime. That was enough to show the rights had vested immediately.
Right. That really shifts the focus away from just physical handover to the legal reality of the transfer.
It does.
So wrapping this up, what does this all mean for you, our listener? I think the key takeaway is that the Supreme Court is truly focused on when the rights to property are vested. Is it immediate, or is it after someone's passing? That distinction is paramount, much more so than the title on the document.
Absolutely. And this encourages, I think, some critical thinking about property transfers. Knowing that the name isn't decisive and that these composite documents can exist, it prompts us to look beyond the labels. Perhaps this makes you wonder, what assumptions might you be making about the documents governing your own property or maybe those of your loved ones? Definitely something to mull over.